So let's talk a little bit about USPTO. The USPTO has about 13,000 employees. Most of the employees at USPTO are PAN examiners, such as Chris. Majority of the workforce here will be the PAN examiners side. We do also house trademark attorneys, which actually examine all the trademark applications. And we also have administrative patent judges, administrative trademark judges, and they help handle the process on the patents and trademarks, rulings and appeals that may happen within the process. So USPTO is also an agency under the Department of Commerce. So some people may not know, but we are a fee-based agency as well. So we operate based off fees that we generate off the patent and trademark applications. So we're one of the few fee-based agencies that the U.S. has. We still have to ask Congress for permission on how to spend money, but we're just not taxpayer funded. We're just a little bit different from other federal agencies. And as you can see, some of the highlights on PAN applications filed last fiscal year, we have 650,000 approximately, and about 370 4,000 were issued. So it doesn't necessarily mean, those out of those 650,000, the 374 were issued. It usually does take a little bit longer than a year to get a patent issued. And we do have patency metrics available on our website to kind of show you what our average length of time is for patents. It really usually depends. That's the political answer I'll give you, but it really does because of the nature of the application. Some of them are going to be a lot easier to process than others, depending on the content itself, of course. For trademarks, the trademarks do process a little bit faster than the patents because of the content as well. But even then, right now we're having a record number of applications, so we are a little bit behind than our traditional patency numbers. So it's just taking it a little bit longer to process trademarks at the time. As you can see, we do have about 732,000 on average trademark applications getting every year, or we at least got last year, and about 337,000 certificates of registration. So this kind of gives you an overview of just kind of the numbers that we see throughout the year in our processing and some of the staff that we have and the numbers that we have here at USPTO. And down here, we do have our USPTO headquarters in Alexandria. And that used to be the only office for USPTO, but thanks to the Americans in BENSAC, now we're able to expand and have local outreach around the nation. So these are the local regional offices in the area. Of course, we fall under the Texas Regional Office, which covers 8 states. I know it says Texas Regional Office, but we do cover the states named below. So we have Texas, New Mexico, Oklahoma, Louisiana, Arkansas, Mississippi, Alabama, and Tennessee. And this area of coverage is mainly for outreach. So this is the people that we interact with to receive stakeholder feedback, people we interact with to educate them on intellectual property. So it doesn't necessarily mean that we only process these areas of coverage on trademarks and patents. It just more means that the outreach is more localized. There's more of a presence within the area. Um, and if you submit something with here in Texas, it's more likely going to get examined outside the area just based on numbers. Just to keep that in mind. So we do have our Texas regional office here in Dallas, Texas, downtown in Dallas. So here we do house PAN examiners, PTAB judges, management staff such as myself, and we help educate the public within our facility. Down, but we are open back to school hours. Did I lose you guys there for a bit?
Yeah, the slide presentation is also not being displayed.
Okay. So I was just talking about the regional office. I'm not sure what happened there, but a little bit of the internet lapse. But is it back up, Chris?
Yes.
Okay, good. So we have the Texas Region Office here slide, and it just kind of talked about the services available. Like I said, we're open back to the public now. We do virtual requests, so if you're interested in visiting, I would recommend just to do a virtual request, and I'll provide our email address at the end. And you can meet with us in person, but at the same time, due to COVID, one of the things that we've experienced is technology advancement. So we can always meet virtually. It's a lot easier and logistically just to meet virtual and meet your one-on-one concerns. So we love doing that, especially to the small business community. We understand that even though our fees don't necessarily generate from the small business community, we understand the importance of educating small businesses so they can understand intellectual property and really, go after patents and trademarks and even if it's copyrights or just understanding trade secrets. We love educating you on that. And you have questions today that you don't want to bring up to the public, in a public setting. Feel free to reach out to us, and we'll definitely make sure to give you some time and sit down with you and educate you on whatever your concerns are. So with that being said, if there's no questions for me, or if there is, just feel free to put them in the chat and I'll answer them. But I'm going to go ahead and pass it over to Chris, and Chris will be talking about the intellectual property basics and the different kinds of IP. Chris?
Right, right.
All right, thank you, Ray. So Chris, and I will be going over the IP basics portion of this presentation. This will be the entry. Just knowing what IP is, the four different buckets of IP, as well as what what coverage you will receive. But if you have any questions, it's a lot of information. Please feel free to use the Q&A feature, and we will answer as best as we can. So with that being said, let's jump in. So the slide we presently see discloses intellectual and property. So intellectual, you see the images representing the basically thinking and brain. Well, intellectual being related to things that are connected to your mind, creative works, inventions, or distinct indicators that you may give, like something that you develop or a business. And then you have the property aspect, where in this image you can see a home for sale, you can see a vehicle, but like property, you can sell it, you can lease it, you can license it, transfer it to friends, families, other entities, and associates. But essentially, anything that you can do with your home or car, you can do with intellectual property. So when you merge the two words, intellectual property, they mean creations of the mind that may be protected by certain intangible property rights. So if could everyone mute themselves if they don't mind? I think some may be unaware that you guys are unmuted. But moving over to the next slide, you will see that there are four different buckets of IP. You have patents, trademarks, copyrights, and trade secrets. So the patent and trademarks, that's what our office covers. Examiners like me, we examine and grant patents, and trademark attorneys will register trademarks. But depending on the business that you have, you may need more than one type of intellectual property to ensure that you have the proper coverage. Most successful businesses will have different forms of IP. Um, and going back to what a patent is an exclusive right granted for an invention. We will discuss the next section past this. Will discuss the different types of patents as well as the different coverages provided. A trademark, as you can see, Gmail by Google, it's a source identifier that identifies your goods or services. So it's a way like customers such as myself or potential customers that you may have will be able to recognize you in the marketplace, and it is able to distinguish you from competitors. Copyrights, it's a registration that's available to you if you register with the U.S. Copyright Office, and it is any original work that usually has artistic element that's embodied in a tangible medium. So think of, like an art, like a painting, or maybe a book that's written, or music that's stored on maybe a storage drive or something like that. And then you have trade secret, and you see KFC. A trade secret is information that either has actual or potential independent economic value by virtue of not being generally known, and it has value to others who cannot legitimately obtain that information and is subject to reasonable efforts to maintain its secrecy. So the next slide shows an image of a smartphone. And while this is one example, I'm sure the device that you're looking from, if you're streaming from your own smartphone or iPhone device or your laptop or a desktop monitor, you can see various elements that are in that product. You know, you probably can recognize Apple logo, or you can recognize an Asus logo, or a Windows logo. But these are various examples of the various intellectual property that's all around us. So in this particular example, uh, it encompasses all four buckets of IP. So trademark, you can see the Samsung logo, as well as the product Galaxy by Note. And then for patents, maybe you can physically see, some you can't, but you can recognize a camera, a battery, screen, as well as an antenna, or and a semiconductor circuits that's behind, the screen. The design patents, which we will go over, but you can see the home button has a particular shape, the curved bezel, as well as the curvature of the screen. Copyrights will cover, the software code that operates the operating system, that makes the operating system run. You have the instruction manual that either came with the device or maybe loaded into the device, as well as various ringtones. And then trade secrets, would it be any secret? I'm sure they have some intrinsic trade secrets for Samsung, but uh, it should be question marks, right, to ensure that it is unknown to all of us. So I'm going to pause right here for a quick second before we hop into the patents section of this lecture, this webinar. But if there's any questions, feel free to use the chat box. And I think we're good. I think we can move to the next slide, right? All right. So, what is a patent? Um, a patent is a grant of a property right to an inventor, and what that right does, it excludes others from making, using, offering for sale, or selling, importing the invention in the U.S. And I think what many people seem to think is that a patent gives you the right to make, use, offer for sale, or sell and import that invention in the U.S. But it's actually the right to exclude others from doing that. The next slide. Can I have a quick question? Can software be patented? Um, so the code for, like, the software code itself cannot be patented. That code can be copyrighted, but the the way that the software executes and makes the device perform some function can be patented. So it'll typically be a device that stored code, that's executed, that's stored in memory and is executed by a processor to perform some function. That particular function is the patentable subject matter. And I think we have another question. And questions: what or where is a good place to find a trademark or patent attorney in the Dallas Fort Worth area? Okay, so Ray will be covering the resources portion, and the resource portion will cover aspects of, what we provide on our website. Quick resources so you can find local attorneys and trademark attorneys in your area, as well as coverages that you may be able to receive, such as pro bono services. So if any questions related to resources, you can wait till we jump into the resource portion.
And I'll share a link with you, Greg, right now, just so you can see a link of patent and trademark attorneys registered with the USPTO. The only thing is we can't really recommend like a location or attorneys, of course, conflict of interest. But yeah, we'll definitely share more resources for you later on so you can kind of have better idea of what's out there and some of the resources you can take advantage of.
All right, great, thanks. All right, and we can go to the next slide too, Ray. So a patent, there are three different types of patents, and each different type protects a different type of invention, as well as it has different coverages of protection and from where the coverage actually starts. So, um, a utility patent can be granted to anyone who invents or discovers any new and useful process, machine, articles, or manufactures, compositions of matter, or any new and useful improvement thereof. So the utility, as you can see from the slide, the those are the four common categories within a utility patent. I myself examine mostly process machines and articles of manufacture, but the coverage begins 20 years from the filing date of the application. It looks like we lost the presentation again, Ray. Let's see. All right, looks like we're back up and running. Yep. Okay. So an example of a machine would be something that's composed of moving parts, such as an engine or a computer. An example of article manufacture is something that is manufactured by a human or by a machine. So like brooms, candle holders, processes are like business processes, softwares, methods, and then compositions of matter. You can consider that as pharmaceuticals. But according to USPTO, more than 90% of the patents that we grant are utility patents. So more than likely, if you have an invention, it's probably going to fall under the category of a utility patent. Design patents are granted to anyone who invents a new, original, or ornamental design for an article of manufacture. As you can see here, it protects the way the product or article looks and the ornamental expression. But the key difference is, as utility patent covers 20 years from the filing date of the application, this actually covers 15 years from the date of grant. So those are two completely different dates. As Ray said, when you file an application, you may not typically get an application granted for a few years. So keep that in mind. A plant patent, it protects, it's granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of patents. I don't think these are very common. And if you have any particular questions, we can go over this. But my expertise is not with plant patents, and I don't. It's a very unique category within that type. But if we go to the next slide, you'll see a fun fact. So this slide is disclosed Abraham Lincoln, and in May 22nd of 1849, he actually received a patent for a device to lift boats over shoals, but he never manufactured this. And I think what's interesting about this is you do not need to have something that's like a sample of your invention already created to file that application. You just need the idea. You don't necessarily have to manufacture that, but it does make him the only U.S. president to hold a patent. I believe Thomas Jefferson was also the first patent examiner. So those are two facts that you may not have known, but now you do. But the next slide actually discloses an example of a design patent, and this is design patent is over a video game system. So it's two different Xboxes, and easy ways to recognize that it's a design patent. It will say United States design patent on it. You'll have a USD number, and it'll show what the shape is, the ornamental feature. But this covers like shapes or configurations, service ornamentations applied to an article, jewelry, furniture, beverages like the Coca-Cola bottle that we all know and love, as well as computer icons and our fonts are examples of designs that can be patented. And actually, the first design patent, because I actually had to look this up recently, was it was actually so typically design patents they provide show what the design is. The first design patent actually was expressed in word. So it did not use any figures, but it was expressed in words, and it was granted in 1842. And it was handwritten as well. So thought that was a pretty interesting fun fact. Next slide, Ray. Here's an example of a plant patent application. As I said, they protect distinct and new varieties of plants. and the plant must be asexually reproduced by the creator. So the next slide uh, discloses the pathway to a patent. Um, and as you see, there's four different steps, one being optional, but typically how it always starts is, you know, you have a new idea and you want to see, you know, whether or not that idea is new or novel, as we like to call it. So typically what everybody does is they do a quick search. You know, you hop on Google, you know, you type in certain keywords to describe what that invention is, and you try to see if it's been, you know, if someone out there has, you know, created it. So a good search tool is the Google Patents website. They use our databases, but they also are connected to foreign databases. Another good search tool is the Patent Public Search tool that we just recently released back in June, as well as, since you guys are in Dallas, you can also go to either the Texas Regional Office as well as the PTRC to perform either of these searches. But let's say that you perform the search and you are unable to find online that particular idea that you have, and you think that it's, you know, something new. So what's something optional you can do is you can file what's called a provisional application. So I know when I was younger, I remember these commercials. It was like a caveman, and it was like a wheel that was being invented, and I remember hearing the phrase provisional application and having no idea what that was. But I'm here to tell you that what as Ray had explained earlier, with the transition to the America Invents Act, we became first to file country. Prior, we were first to invent. So what this means is, first to file is, it's a race and a placeholder. It's very important. So it doesn't matter when you invented it. It goes, the patent will go to the person who first filed it. So what a provisional application does is it gives you an opportunity to put yourself in the queue, and you will have 1 year. All you need to do is file a specification and a set of drawings. And obviously, you want to file as descriptive of a specification and drawings to ensure that, you know, you do receive that coverage if you decide to file a non-provisional application. But it gives you the opportunity to see if, you know, it's your invention is marketable. You can pitch to presenters and investors like on Shark Tank, you know, and then you can, you know, work on your product, but you don't trigger any statutory bars, which will result in losing your actual patent protective rights. So the initial cost is going to be lower because you're not filing claims. Claims are the result of why your application will be higher, but it's not really a cost reducing strategy because you still have to file your non-provisional application. It's more like a cost delaying strategy. So, but it just also gives you an opportunity to use the phrase patent pending, which I'm pretty sure a lot of us have heard. But 1 year passes, and if you decide that, hey, or I think you can even, yeah, 1 year passes. Most applications that I've examined, and a non-provisional typically follows after that. And with the non-provisional application, that's when you're ready to, you know, step on the court. And so you file your full application, claims, drawings, and it'll be assigned to an examiner like me. You know, within a year or two or three. I'm not sure how soon, because it varies depending on which art it is. But I would then examine your application, and then if you decide that, hey, you know, okay. Okay. So the question was essentially, uh, what patent coverage can you receive for a revised product, right?
Yes.
Okay. So it depends. The patent that's awarded to you is the claims that describe your product. So if you make revisions to the product, and those revisions are not what's claimed in your patent, then those particular revisions could be would not have that protection. However, if a specification has been filed, for instance, and within the specification you do have different embodiments for different for different features or different ways of modes of operation for that product, you can file what's called a continuation, which will have that same coverage date, but it will, it can be directed towards subject matter that's a bit different from that application or that claim, I should say. But if you are, but if you're improving upon an invention, and let's say that December 2010 you created product A, but by December 20 like 17 for instance, you notice that okay, there's like blockchain technology, new technology that's available that wasn't, and then technology, you're able to file a new application, with that same product and the improvement thereof. And as long as it's not considered obvious, you can receive protection for it.
Okay. And what if you're putting a product together that is made of um, other products? Is that considered yours? You finding you use by combining multiple other products? Is that
So
patentable?
so what you have to assure is that it cannot be considered obvious. So like if you, for instance, if it will be odd for if like you had a bottle or a cup, right, and you put a lid on a cup and say that, well, this is a new product. Well, if examiner finds a prior art reference is what we label the publications that we use to reject the application. If he finds or she finds or they find two uh, applications that discover a product and a lid, and then one gives motivation to combine, that would prevent you from being able to patent that. If it's been like if that obvious feature has been disclosed in a prior art. So we also search for that too. But that's a little more, I guess, low level and I guess outside the scope because we're getting into like the technical aspects of it. So I don't want to confuse you, but if you have any like special questions, we can set up a one-on-one and we can go over those high level, I mean those low level technical questions
That's
after
great.
this.
Thank you. I
Okay,
appreciate it.
no problem. All right, so we're gonna hop right into the trademarks. So what is a trademark? We can read the slide together. Trademark is a word, phrase, symbol, or design or combination of the word, phrases, symbols, or designs that identifies and distinguishes the source of the goods of one party from those of the other. So, as I mentioned earlier, businesses sometimes have uh, more than one bucket of IP to ensure they have full coverage. And you may think that, hey, well, a design patent, trademark and copyright, they kind of all blend in, bleed in together. But the legal coverage provided by each varies, and educating yourself over the differences is the best way to, protect yourself and know what coverage you will receive. The best example I usually give for this is me being in New Orleans. I mean, I know you guys are in Dallas, but if you were in Houston near the Gulf Coast, you know that we have hurricanes, frequent hurricanes, and for me, I would have to ensure that if my home is protected, I have to have both homeowners coverage as well as flood-based coverage. Uh, in the event that we have water damage or we have damage from wind or hail, intellectual property coverage is the same thing. A trademark is not going to be the same thing as a patent or a copyright or a trade secret. So a service mark is the same as a trademark, except that it identifies and distinguishes the source of a service rather than a product. So next slide, Ray. So as I mentioned earlier in the discussion of the Samsung Galaxy Note, we see intellectual property all around us. And here's an example of common trademarks that we see. We see trademarks that are words, such as Starbucks, the Nike. Also see designs, such as the Starbucks logo, the Nike swoosh, and the Target. logo. So one thing to note is that in terms of I guess brand recognition, trademarks do have a tangible value to your individual business. So your protection, trademark protection, as well as intellectual is territorial. What this means is um, you can file a trademark at the local level, at your state level, which will provide trademark protection within your state. But if you feel your business is an expansive business, in which you will do, business in the other 49 states and territories, then you will need a federally recognized trademark, which you file with the USPTO. So, and keep that in mind. And to know the differences between a national trademark versus a local state recognized trademark. Next slide, Ray. Okay, and so for me, hopping on this detail, I've as a patent examiner, my job duty has been strictly patents, but I've learned, in trademarks that trademarks are not only just are recognized by words and designs. You can have what are called non-traditional marks. So in this example, we see the non-traditional marks of, the Tiffany blue box. You see the UPS brown logo as well as the John Deere green logo. Um, the slide after this, I believe talks about the non-traditional marks being representative by scent. Next slide, Ray. So uh, as long as they're used in a non-functional manner. So you have the strawberry, cherry, grape blueprints engines to, make the exhaust smell, the groovy grape. Verizon has a flowery musk scent in their stores. I don't know if you know that. I don't have a Verizon phone, so I cannot verify that, but that's what I've heard. And then Play-Doh, Play-Doh has an actual the scent of, that's like musky, vanilla, fragrance. Overtones are like cherry. Kind of smell like a weeded based dough. That's an intentional scent, strictly made for Play-Doh. Um, and then the next slide, I believe, talks about sounds. So you have Pillsbury Doughboy, NBC's logo. I mean, uh, dum dum dum, as well as the Mario coin. These are also other ways that you can distinguish your business through trademarks. That are not just words and designs. And the last is what we call trade dresses, and so these are a type of trademark that refer to the design or packaging of a product, and it's intended to protect the consumer from packaging or appearance of products that are designed to imitate other products. So, counterfeits. So, as with all trademarks, they must be non-functional, but trade dresses must be distinctive. That means that the consumer perceives a particular trade dress as identifying a source of a product. Um, in this example, we see in Dr. Martin boots, they have yellow stitching in the welt area of the sole. And then you see they have a two-tone sole edge with a distinctive DMS sole pattern and black fabric hills. You see the Coca-Cola bottle shape. Uh, the interior design of the Apple Store, every Apple Store I'm sure you've been across, looks exactly the same, as well as Hershey Kiss shapes. You can even think of the Christian Louis Vuitton red bottoms, the shape of a Maker's Mark, the bottle with the red wax top, as well as the shape of Ferrari. These are common examples of various trade dresses. So this covers the trademarks portion of the presentation. If anybody has a quick question, because we only have 19 minutes, it seems, you can bring it up or use the Q&A feature. But if not, I'm going to hop right into copyrights. All right. So we at the USPTO, we do not deal with copyrights in great detail, but we do advise people on copyrights. So a copyright is a legal protection for original works of authorship, including, excuse me, literary, dramatic, musical, artistic, and certain other intellectual works. So copyrights they're a bundle of rights that gives the owner the right to make copies, prepare derivative works. So this would be modifying. Um, you can distribute copies. You can perform that work publicly as well as display that work publicly. Next slide, Ray. So things protected by copyrights can be songs, movies, books, sculptures. Um, I think the next slide also gives some further examples. Yes, as well as logos, product designs and packaging, advertising and promotional materials, software source code, website content. So the key thing about all of this is that while it appears that there may be some overlap with design patents, what a copyright has that a design patent doesn't have is you have a longer protection than a patent. You have 70 years plus the life of the author. Um, and so you would if you wanted, if you do have something that's copyrightable, you can go to the Library of Congress where the copyright office is to seek that protection. And I believe the cost is it's a minimum cost, which are in line with trademarks, whereas obviously a patent is going to be more costly to file. So, and that, as you see, a logo can serve as a trademark as well as a copyright, and it can also, I believe, serve as a design patent. So, I believe that is the last. That's the last slide for copyrights. If there are any questions, feel free to let us know. If not, we can jump right into the last bucket of IP, trade secrets. Okay, so what is a trade secret? As we can see from the slide, a trade secret will consist of information, and it can include a formula, a recipe, process, many different creative works. But the most uh, uh, the key thing about this is that the most common definition of a trade secret is that it has to be used in business, and it has to give you an opportunity to obtain an economic advantage over competitors who do not know or use it. Next slide. And these are things obviously that cannot be easily re-engineered, like formulas and patterns and compilations. But um, as you can see from the slide, uh, patents and trade secrets are really different sides of the same coin. So you have a quid pro quo duty for a patent, whereas the trade secret is always going to be a secret. So a utility patent, it lasts 20 years from the earliest U.S. benefit date claim. So that's the filing date. Whereas the trade secret will last as long as it remains a secret. For the patent, you must disclose how to make and use your invention within your application, whereas a trade secret, you must take reasonable steps to keep it secret. There may be legal remedies should someone, make or use that invention without your permission for a patent, whereas there may be legal remedies should someone steal your trade secret. But someone can try to sell and improve upon what you have already done to get a patent, whereas someone can still try to reverse engineer what you have done. The last slide gives four different examples of trade secrets that we know that we may not have recognized that are trade secrets. So Coca-Cola has a classic formula, Krispy Kreme. They have a classic recipe. So does KFC, and then Google has a page rank, which is a hybrid. That is the original hybrid of the original formula, but the way they combat the manipulation of its algorithm by link farms and other tools is a constantly held, trade secret. The last slide gives a great summary table of the four various different buckets of IP, as what they are, the requirements, how long they last, and then what rights as an inventor and what they protect you against. So that concludes my portion of the IP basics presentation. If anyone has any questions, feel free to use the Q&A feature. I will do my best to answer them. And with that, I'm going to turn it over to Ray, who will go over the USPTO resources. Thank you. All right, Ray.
Thank you, Chris. And Chris will be manning the chat in case you have any questions. So you feel free to use that. I'll go over USPTO resources. A lot of people don't know, but the USPTO does provide a lot of resources for them to learn more about intellectual property and really take advantage of the patent and trademark system. So our number one resource is definitely our website. It's used a lot by educators. It's filled with information from USPTO and just knowledge, things to know. You can also subscribe to our newsletters in there. That's our number one way of communication. I definitely recommend you guys to go ahead and subscribe to keep up to what USPTO updates and events such as these and other programming that we have throughout the year. We do have a web page dedicated for startup businesses just to kind of understand some of the IP side from state and local resources to pro se programs for individuals that want to represent themselves, scam prevention, education, and really the startups on patents and trademarks. So good information for individuals that are barely getting into the IP realm. We do have 1-800 hotlines for trademarks and patents. So these are used a lot, and actually they're used a lot by the legal community. So every time I talk to the paralegals and even attorneys, young attorneys, they use this hotlines to help them guide them through the process and any basic questions that they may have. And just remember, we're USPTO, we're a federal agency, so we can't give any legal advice. But definitely, they can guide you and try to get educate you as best as possible so you can make informative decisions. And this is the Inventors Assistance Centers, which focus more on the patent side. And of course, these slides, you can request them to Regina Harris, and she's providing the information on the chat. And you guys can reference the slides that way. So we do have a profile option that you can create. This is tentative usually useful for individuals that are a good way to kind of get quick links to references to any examiner that you may be dealing with. And we do have an app specifically for trademarks. So in case you wanted to check the status on your trademark application, you can do that with the app as well. We do have an IP awareness assessment tool. This one helps you understand your specific intellectual property threshold per se. So if you put your situation, it can give you a good assessment of what different types of IP you may be hitting. This is used a lot by business counselors with individuals that they're dealing with, but you can feel free to use that for free. We do have pro bono programs, and the pro bono programs is something that USPTO recognized it is costly to go after a patent. So definitely look into the patent pro bono program if you're interested. You do have to have the following requirements. Um, have an income of 300% below federal poverty guidelines. Some states do go down to 200%, but look into that. That's probably the biggest threshold. Pay USPTO filing fee, then cost, demonstrate a knowledge of the patent system, take a training course at USPTO, and have an application pre-screened to make sure it's more of an idea. So it's definitely some requirements you have to go through, but it's definitely useful and it can help you with the drafting fees. And that's usually what takes the long or the most costs when you actually go after a patent. Like I said, we cover all 50 states and territories in the US. In the state of Texas, we have TALA, which is the Texas Accountants and Lawyers for the Arts. They're located in Austin, Texas. The director is Alyssa McCain, and you can contact them. They also do provide other legal services, like help with business entities. So make sure to keep them in mind and look into their website for other services that they can assist you with. But it's good that they have the IP side because a lot of organizations don't have IP. We do have law school clinics that we work. These law school clinics are law schools that have students, 3, 4 year students that are actually getting experience in helping you draft your application. And they're supervised through a clinic supervisor which has IP experience. They're certified through the USPTO. It's a win-win. Students gain experience, and you get pro bono services with drafting on, and they can do trademarks and patents. Here in the state of Texas, we do have 4 organizations. Baylor, South Texas School of Law in Houston, SMU here in the Dallas area, and Texas A&M in Fort Worth. So definitely feel free to reach out to them, see if they can assist you with any other pro bono services. And we do have PTRCs. These are actually I won't steal the thunder from Kathy. I'll let Kathy. I did invite her in here because I did see the value of bringing her in and talking a little bit about her services. Kathy?
Thank you, Ray. Ray, could you go ahead and show my, thank you.
Yes, would.
If you have just recently joined us or missed the first part of the introductions, my name is Kathy Berry, even though my email says differently. But you can find us here at Dallas Public Library at the Downtown Central Branch, which is located at 1515 Young Street here in Dallas. We're across the street from the City Hall, but we do have, and I'll emphasize this, we do have a free parking underground, so be sure and make the effort to come around to the north side of the library, which is located, the garage is technically located at 1541 Wood Street. Again, it is free. It provides security down there, so things are relatively safe. Something else I did not put on my slide here is if you need to come down to the library and you want to talk to us, we are open from Tuesday through Saturday, and we offer many services here at the library, but I want to specifically address the ones that are on my slide here. We do have the patent and public search available on any computer. As you probably know, you can reach it on your own computer at home. But we will be able to help you learn more about how to search if you're having some questions about it. Again, we cannot answer any legal questions, but we can help you get started, especially with the classifications. Something that we can help you with is the application process and fee schedule. We can find those and locate them for you and help you understand what you need to pay up front, especially if you're a micro entity, which means you have less than 4 applications. We can help you to learn how to search. We cannot help you search. If you have a question about something, we can guide you toward the answers, but we cannot give you the legal questions that you want to ask. Something that you will also know has already been addressed is the local patent attorneys. You know that if you Google patent and trademark attorneys in DFW, you're going to come up with thousands of them. Well, yes, there are thousands of them. So how do you find the one that's right for you? That's a personal question, but we can help with that as well. And you've already been given the link so that you can find those lawyers. But here we like to stress that on the second Saturday of every month, except for the summer months, we have intellectual property classes here at the library. Right now, we can have a one-on-one questions with a patent attorney. Again, he cannot give you any legal advice, but he can advise you on where to find the correct information. It's not a way of saying that we recommend this lawyer, but he is volunteering his time to come in and speak with you on a one-to-one basis. Or we will have a group setting, and then he will usually answer questions afterwards. The summertime months are difficult to register people because of vacation, so we won't start up again until September. But check out our calendar of events here at the Dallas Public Library. Our organization website is dallaslibrary.org. That'll help you get to our specific landing page to find more information about our calendar of events and when we are scheduling one, and you can register for that one specifically. Now, the next, as I said, we have a patent attorney that comes in and offers his time. He is here for about 2 to 3 hours, depending on how many people register and what service that we are offering. In the past 8 years that I have been here, I have helped people do historical research on patents, both from 1870 up to the 1950s, helping people find their relatives' patents that they knew they had, but they didn't know what they were. And I've also helped people to find information. They were writing research for an article in a magazine, and they needed to find out more about the information that was available on a particular patent in 1879 and where it was done, and the person that was specifically the inventor. In the past, I've also helped businesses to find out the assignee information that they need whenever patents are sold with a business, and they want to make sure that everything has been found. Usually their own research department will find them, but they want to check with us here at the library to make sure that we have all the information that they have. Again, we do want to invite you down to the new Dallas Public Library 6th floor. Yes, we are on 6. We've been newly renovated, especially during the COVID. We had time to do that, and we have plenty of computers for you to use. We have classrooms, we have conference rooms, and we also have a computer that's available when the Dallas USPTO office is closed. They close, their computers are much faster than ours, but we're open on Saturdays and until 6 o'clock at evening. So if you need to, come on down to the Dallas Public Library at 1515 Young Street, park in the free parking garage, which is on the north side, and use the elevator to come up to the 6th floor. We'd like to see you come in today.
Thank you very much. It's important you guys learn about PTRCs because when you have an idea, the first thing you want to do is make research on it. Is the patent already out there? Is the trademark already out there? That's always number one. It's kind of like doing a business plan with your business idea. Always want to do a search because we always think we're the first ones to think about it. But a lot of times I would say there's already some prior art or something similar to it in the past. So that can either help you or just save you a lot of time going forward. So I'm just going to go over these quick slides, or the main one I wanted to talk to was the microentity status. So USPTO does recognize microentity status, and that's with any business under fewer than 500 employees. It does give you 75% off most patent fees and a low cost submission to establish a filing date. So just keep that into consideration for small businesses out there. We're working with the SBDC here, so I'm sure a lot of you would qualify for this microentity status. And of course, these are based on USPTO fees that you'll be dealing with. And at the end, we do have our information. Feel free to reach out to us. I did provide my information on the chat as well, so you can reach out to me directly